Thank you, Judge Arnold, and my thanks to Lionel Bentley and to CIPIL and the many colleagues who I have the good fortune to reconnect with here and new ones who I've met for inviting me to give and talk on this topic. And I really have been fascinated by and have been listening to the presentations today. It's a field that in some ways it's now become impossible to keep up with, which I must say is very different from the shared experience I have, although with a slightly different spin, from the anecdote that Judge Arnold told this morning about these two fields being so separate, and now they become part of the bread and butter work of what courts and government officials engaging with intellectual property do. When I started teaching, I worked in both human rights and in intellectual property separately, and I thought there might be possibly some relationship between the two. And I remember a senior colleague telling me, Larry, you don't do that. They have nothing to do with each other. What are you doing writing on this topic? And my line at the time was, well, I talk to people who don't talk to each other normally, and I learn from from that experience. But time has proven that I guess I had a good nose for this issue, and the world has really gotten much more complicated with respect to these intersections. And the remarks today by Henning, the two Martins, Jonathan, Christina, Siva, and others, I think really give you a flavor of how interesting and rich this area is. And what I would like to try to do in particular with the time that I have, and I'll try to actually be under my time so we can perhaps have more Q&A that reflects on all of the contributions today and hears from all of you in the audience, is to speak in particular about a third approach. It's one that Henning alluded to in his remarks. And I think it comes logically after the kind of normative conflict idea that Henning and Siva and others have referenced that showed up in the early UN human rights system, the idea that if there's an intersection between copyright or trademark or patent and human rights, then if they're in conflict, human rights gets primacy. And Henning said, well, that wasn't really very well developed. I think it rather quickly gave over to a different paradigm, coexistence or coherence. And that's really what we heard about throughout most of the presentations today. The idea about the doctrines of fair balance, proportionality, margin of appreciation, other interpretive principles that are used to kind of reconcile the different competing rights and interests at this interface. What I was really struck by in all of these presentations, and they really were excellent, was what they had in common was the central role of national and international judges in applying these interpretive principles. Lots of court cases on very specific sets of topics, and with more surely to come. But what I want to try to focus on in this third approach is a legislative or treaty-based approach. And the conceptual, description of it that I can provide is one that favors using the legal tools and doctrines of intellectual property law to advance human rights objectives. So this is a kind of deep synthesis of these two fields. And I'm going to do so through the specific example of a treaty known as the Marrakesh VIP Treaty, or more formally, the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. And that's the first and last time you will hear me say the full title of the treaty, which I think reflects how hard-fought these negotiations were. So what's interesting about this treaty, it is the first time that the World Intellectual Property Organization has devoted an entire treaty to exceptions and limitations, mandatory exceptions and limitations to the exclusive rights of IP owners, specifically copyright owners in published literary and artistic works. I've been fortunate enough to be involved not in the negotiations, but in helping to perhaps lead discussions about implementation. And I am the co-author of, along with several other colleagues, of a new book, which I had hoped would be here today. It literally was in print yesterday. So I have a bunch of flyers if anybody is interested. They're, Oxford University Press, so I didn't think it was nice to put them out there. But if anyone is particularly interested, I'm happy to share them with you. You actually have the table of contents, the executive summary, and the introduction to the book in your conference packets. So what I would like to do in exploring this theme of using copyright or IP tools to achieve human rights ends is to divide my remarks into basically four parts. First, the legal and factual background to the Marrakesh Treaty, why it is that this issue has some deeper roots, even though the treaty itself is really quite new. The negotiation of the treaty in 2013 and its entry into force at the end of last September. The treaty now is, in fact, in force. To give you an overview, give you an overview of its core obligations and some of the tension points that I think are going to come up in interpretation and implementation of the treaty, which is now ongoing in many countries around the world. And then close with a few predictions about reflecting back on some of the other presentations that I've heard today and thinking about the future, what the Marrakesh Treaty might hold for the future. So with that, let me start with some of the background conditions, both legal and factual. So let me begin with legal. So if you were to go back in time to 1967, to the Stockholm revision of the Berne Convention, that's where I would argue the origins of the Marrakesh Treaty actually can be found. So that was the conference at which the members of the Berne Union codify the right of reproduction, and it was perhaps even more importantly, the first recognition of the now ubiquitous and never can be avoided three-step test. And I will say that the Marrakesh Treaty makes, I forgot how many references to it, but multiple references. Anytime you mention one thing, you have to counterbalance it with a three-step test. It's really quite remarkable if you were to look at the text of the treaty. So the drafters at the Stockholm revision recognized that in adopting this reproduction right, that there were certain long-standing exceptions and limitations in national law that would presumptively meet and be compatible with the three-step test. And one of the areas that until recently had received very little attention, very little controversy, I would say, were reproductions in special characters for use of the blind and sound recordings of literary works for use of the blind. So these were among a enumerated list in a background report at the Stockholm revision that referenced what E&L's exceptions and limitations in national law would be presumptively compatible. So why were these mentioned? Well, they were mentioned in part due to the fact that many countries that were members of the Berne Union had already enacted exceptions permitting persons with visual disabilities to create or share copies in accessible formats. At the time, mainly Braille, as I'll explain in a moment, that the formats have changed enormously since then. So there were countries that already had this provision, and they wanted to be sure that exception could continue permissibly with their updating and expansion of the rights in the Berne Convention. And since then, a number of other countries have adopted similar exceptions in their national law. So the EU, of course, in the Info Society Directive 2001 contains such an exception. The United States, the Chafee Amendment to the U.S. Copyright Act of 1976 is another example. But not all countries had these sorts of exceptions, and especially countries in the developing world did not tend to have these exceptions. Prior to the adoption of the Marrakesh Treaty, about 1/3 of countries that were party to the Berne Union had these exceptions. So, common, but not by no means universal. And that brings me to discuss some of the factual backgrounds that created the impetus for this treaty. So these exceptions in national law have been around for quite a while. So why was it that there was a momentum toward creating a new international agreement on these issues? Well, among other things, there were reports and studies both by the World Health Organization, by advocacy organizations, by scholars, documenting just how serious the problem was. As the World Blind Union, which is the author or the kind of inspiration for this guide that I've just co-published, has said, they use the phrase book famine to address the fact that there are nearly 300 million people around the world who are blind or have various forms of visual disabilities. 90% of them are in developing or least developed countries. Only 5% of published works are available in formats that are accessible to persons with visual disabilities. And so those are together what made up the phrasing of the so-called book famine. But in addition, another factual support as background for the Marrakesh Agreement was the profusion of new technologies that allowed copyrighted works to be made into a variety of different accessible formats. Electronic braille, DAISY, screen readers, text-to-speech functions, e-readers. Some of these technologies are specific to people who have visual disabilities, very large print books, another one. Others are so-called dual-use formats that can be predominantly used by people with visual disabilities, but by no means exclusively. And with the rise of these digital technologies and the online communication structure available to distribute the relevant files, it became clear that it really didn't make sense at the national level for each country to develop its own reservoir or repository of accessible format works. That, in fact, there would be enormous efficiencies and savings if governments could coordinate around the sharing of accessible format copies across borders in ways that would still, nevertheless, protect copyright owners. So these factual predicates intersected with some of the legal predicates, and I would say a few other things happened around 2004 to 2007 that started this process going, leading to Marrakesh. The first was the adoption of the Convention on the Rights of Persons with Disabilities, the CRPD. And Article 30 of that convention, I do human rights law separately from IP law, but I confess I didn't know for quite some time, because I didn't make it all the way to the end of this rather lengthy new human rights convention from 2006, the provision that says that states parties to that convention, of which there are now some, I think about 170 or so, undertake to ensure that laws protecting intellectual property rights do not constitute an unreasonable or discriminatory barrier to access by persons with disabilities to cultural materials, end quote. So I just quoted that phrase to you, and that phrase indicated that within the disability rights community, within the human rights community, there was an awareness that for this particular category of beneficiaries, the copyright system and intellectual property norms in general might not in fact be serving their interests and might in fact be acting as a potential barrier. So this treaty was widely ratified. It came into force very quickly and has been accepted by most nations around the world. It has a highly organized and mobilized set of stakeholders, human rights NGOs, disability rights organizations, and so forth. And this development intersected with an initiative in WIPO you are all, I'm sure, familiar with, the WIPO Development Agenda, one aspect of which was the study of what, in fact, existed at the national level with respect to exceptions and limitations to benefit visually impaired persons. And WIPO published a study in 2007 that showed that, in fact, there were gaps in laws. The laws were unclear. They weren't technologically neutral, so it wasn't clear whether they could apply to a new format, accessible format works. Nor was it clear in many instances whether those works could be imported or exported among countries, even among countries that had these exceptions. And I think probably most importantly, not to move from facts and law to politics, those countries that had a strong interest in upholding the existing international IP system had exceptions and limitations already in their national laws. And so therefore, the US, the EU, and other countries could conceptualize this as being something that they could see perhaps as part of a binding multilateral instrument. So I won't go into the negotiations leading up to Marrakesh. Others can speak to that more than I can. What I can say is that a group of key countries, both developing and developed, came together during the diplomatic conference in Marrakesh in June of 2013 and hammered out a set of compromises that really does, I think, represent a new approach to thinking about these two fields. It is rather remarkable that WIPO now has a treaty that is designed, I would argue, to promote human rights using the tools of copyright law, and that it mandates exceptions and limitations in national law. We have not really seen that before. Yes, there are a couple of provisions of the Berne Convention, but they're pretty narrow, and this is an entirely different beast altogether. So 2013, about 50 countries signed the Marrakesh Treaty. The ratification campaign that being led by the World Blind Union, among others, goes forward, and Canada on June 30th of last year deposits its instrument of ratification, bringing the treaty into force 3 months later at the end of September. On that day, I learned, I was in Geneva the day after the treaty entered into force, actually trying to explain to a number of disability rights groups why they actually should care about intellectual property law. Many of them had not really thought of that before. That community is very diverse, as are many other communities. But I learned on that day that a number of libraries for the blind in Latin America, on the day the treaty entered into force for those countries, started sharing electronic files of accessible format copies among themselves. They hadn't done it beforehand because the legal landscape was unclear as to whether that kind of sharing was permissible or not. But on the day it happened, a request from a library in, if I'm remembering correctly, Chile, to another library in Argentina said, well, do you have Pablo Neruda's work in e-braille? Yes, we do. Could you put it on Dropbox, that's just limited to, sure, no problem, here it is. So that struck a chord with me. So, implementation, which I'll talk about in a moment, and which is vitally important, which is why I joined this project on the guide to the Marrakesh Treaty, is itself, has a number of different aspects to it. But I was struck that among these civil society groups, among non-state actors, the very existence of the treaty and its entry into force facilitated the sharing and exchange of accessible format copies. And I would argue it does so consistently with the existing international rules existing international IP treaties. So the next stage in the process, which is going to bring me to the third section of my remarks, goes to what actually happens now in terms of implementation and interpretation. So the Marrakesh negotiators set up a framework that I'll describe to you in a moment that has a number of key components to it. But not surprisingly, like any contentious treaty negotiation, there were many provisions that were left ambiguous, deliberately so, or there were optional clauses where it was expressly noted that states had the possibility of, although not the requirement to, modify the template that Marrakesh sets forth. So the fight, to the extent there is a fight between the publishing industry and the disability rights groups, is now moving to the national level. And there will be quite a bit of discussion, I'm sure, in copyright offices around the world over what to do in this regard. So the guide attempts to give some recommendations to governments, to civil society, to scholars, policymakers, and others as to exactly what the treaty means. And as IP lawyers, I imagine you could read the treaty with no problem, but for human rights lawyers, it is written in Greek. It does not resonate with the kinds of respect, protect, ensure framework that we heard about earlier this morning. It needs translation. And part of the goal of this enterprise is to provide that sort of translation. And what to do with the different optional provisions and ambiguous clauses. And again, to reiterate, the basic approach that we've adopted is that the treaty, its goal is to expand accessibility of copies that are consumable by individuals with visual disabilities, and to do so in a way that is also consistent with the obligations that governments have already undertaken with respect to the CRPD, the Convention on the Rights of Persons with Disabilities. So we see a real deep synergy between these two conventions, and we think that governments can actually build on what they've already done when giving effect to this treaty in a way that would bring it into force in a manner that would benefit its beneficiaries. And I'll say more about that in just a moment. Okay, so what exactly does the Marrakesh Treaty require? Now, I'm going to oversimplify here in the interests of time, just to give you a flavor of what its core provisions are. And I will go into a little bit more depth on some of its essential, what I would call its kind of core obligations. But obviously there's much more that we could talk about and the treaty does talk about. So I want to divide the obligations into basically 4 different parts. I want to just mention the preamble, the definitions that the treaty contains, some of the key definitions, that's the second point. Go through these core provisions about the mandatory exception to exclusive rights of copyright owners and the relationship to the 3-step test, and finally turn to implementation. And so that's kind of the overview I want to provide of the treaty. So Henning, I think this morning showed you the first 2 preambular clauses from the Marrakesh Treaty, which do contain express references to 2 human rights instruments, both the Universal Declaration on Human Rights and the CRPD itself, but also more broadly to the importance of copyright as a tool to realize both the human rights of creators and authors and persons with visual disabilities. So when we talked about the sort of balanced human rights being on both sides of the incentives and access equation, both in the human rights regime as well as in the copyright regime, that's reflected in the preamble. The preamble also reaffirms that it is essentially building on and is consistent with the Berne Convention, the WIPO Copyright Treaty, and the 3-step test, which, as I mentioned, is sprinkled liberally throughout the instrument like strawberries over a bowl of cornflakes. I mean, you sort of any time, you when in doubt, throw it in. I think the preamble helps to indicate what the objectives of the treaty are, and the approach that we advocate in the WBU guide is that the treaty should be interpreted in light of those objectives. That it does attempt to strike a balance. It provides a kind of compromise position that protects copyright owners, but also seeks to radically expand the access to accessible format copies for people with visual disabilities that have long existed in many national laws. So just a few words then about key definitions in the treaty. And again, I'm going to simplify. So covered works, primarily literary and artistic works. There is a carve-out for audiovisual works. Those are covered by the Berne Convention, not covered deliberately by the Marrakesh Treaty. That was essential, I think, in order as a political matter to get things done in terms of making the agreement. So covered works, mainly literary and artistic works. There is a definition of accessible format copy. That definition, I am pleased to say, is technology neutral. So unlike attempts to talk about copies in particular modalities that may have existed in the past or might exist in the future, this is a functional definition that is defined by reference to the extent to which the technology makes these works available to VIPs, visually impaired persons, on the equivalent terms to people who are fully sighted. So it's a very important definition. 2 other definitions. The treaty defines a class of beneficiary persons. Those are the people who are blind or otherwise visually disabled. But the definition is rather broad. So it includes not just blindness or visual impairment, but also individuals who have perceptual or reading disabilities. So an individual unable to move because of ALS disease, so like Stephen Hawking, would be covered by the treaty, as would an individual with dyslexia. And there's some marginal questions around the margin, but the idea was to provide a broader different definition than just blind and severe visual impairment. Final definition, and I think this is really quite an important point, a linchpin of the treaty, is a definition of so-called authorized entities. As you might imagine, people with visual disabilities, particularly in countries with limited resources, will rely on families, on caregivers, on community organizations, on libraries for the blind, if there are any, in order to be able to read a newspaper, read a book, access cultural materials on the internet, etc. So it isn't always possible for the beneficiary persons to do this themselves, and so the treaty recognizes a category of authorized intermediaries, if you will, that are empowered to both create and share accessible format copies. Now, these are most obviously the kind of specific disability rights organizations like Libraries for the Blind, that's their raison d'etre. But there are many other organizations that have as one of their primary purposes serving people within this community, and they, we would argue, qualify as well, provided, to again oversimplify, that they are not for profit and that they adhere to a set of practices with respect to record keeping and ensuring that only those individuals with visual disabilities are going to be able to access these accessible format copies. So they are key intermediaries in that regard. Let me then turn to some of the core provisions of the treaty. These are in Articles 4, 5, and 6. But basically what I want to just say is what the treaty does is provide an obligation to adopt an exception in national copyright law to the exclusive rights of reproduction, distribution, and making available. There's also an optional extension of that exception to public performance rights. So exceptions to exclusive rights that I mentioned are mandatory, as are permitting beneficiaries and authorized entities to exchange accessible format copies across borders among contracting parties. I want to be clear that the treaty itself only applies to those states to whom it is a party. There's an open question, perhaps, about whether a state could go beyond that and share copies with non-parties. Hopefully that will become a moot point as more and more nations ratify, but it might become an issue in the medium term. So in essence, this framework not only allows the creation of accessible format copies in new and technology-neutral formats, it also enables their sharing across borders. So, to give you an example, if you have a person with disability or a group that represents that person in Cameroon, which I would venture to say probably has very few books in accessible formats, they may simply submit a request to another authorized entity, say in France, which has a much larger library of accessible format materials in French, and share those materials across borders. It's no longer necessary, nor would it be realistically possible, even if it were necessary, for Cameroon to create its own digital library of these sorts of accessible format materials. So that's how it's intended to work, right? That there's supposed to be a kind of pooling of these works, literary and artistic works, for the benefit of people who have visual disabilities. So immediately, the hardcore IP lawyers in the room will be asking, what about the three-step test, right? Is this consistent with the three-step test? And the perspective that I think the better reading of the treaty, and there are, I will acknowledge, divergent views on this, is that if a state follows the requirements set forth in the Marrakesh Treaty, including the protections it provides for copyright owners, and if it adopts a bespoke exception to copyright to benefit VIPs, then that is a safe harbor that is presumptively satisfies the TST. I think that's consistent with the history of the TST and its origins as recognizing an exception for people who are blind. I think that's consistent with the fact that this is a multilaterally agreed solution to a problem that many countries, most countries have recognized as a very real problem, a very pressing problem. So there ought to be a way for a state to follow a template and not worry about being challenged before TRIPS dispute settlement or TRIPS Plus treaty, that this is inconsistent with a three-step test. And I think if states follow the script in the Marrakesh Treaty, they will be compatible. Now, they have other options. I want to be very clear. They can decide to use existing or open-ended exceptions and limitations, fair dealing, fair use, private copying, etc., to achieve the same purpose. But if they go that kind of bricolage or ad hoc approach, then I think it's not clear that those exceptions are presumptively compatible with the three-step test. I think each exception would have to be examined in terms of its application in specific contexts and on the facts. So I would urge, and the guide urges, that the states follow the sort of preferred script of a bespoke, that is a specific enumerated exception for visually impaired persons. Okay, I want to just mention in passing that there are two important optional clauses with regard to these core provisions of the treaty. One, the so-called commercial availability option that permits but does not require countries to ban the creation of accessible format copies if the copyright owner, usually a publisher, has already made that work available in a particular format. Now, there's a real question about whether that kind of optional provision would be quite burdensome or chill the exercise of the rights that are guaranteed in the Marrakesh Treaty. In the past, most publishers had not served this market. I think it would be wonderful if they did serve this market, but there are a lot of open questions about exactly what commercial availability would entail. Is it format by format? To how much of the market actually has to be served? Is there a reasonable price requirement? All of those uncertainties lead me to suggest that governments ought to eschew that option. The second option is one of permitting a state to require remuneration as a condition of creating and distributing accessible format copies. And again, the suggestion is to be fully consistent with their obligations under international human rights instruments, and in particular the CRPD, and to avoid the danger of a chilling effect on the exercise of these rights by beneficiary persons, that states should avoid that. And in the European Union, the proposal that has been put forth in a regulation and a directive of September 2016, may have been modified since, if so, please correct me, avoids both of those optional provisions and does adopt a bespoke exception to the InfoSoc directive of 2001. So for the most part, although there are disagreements about some of the details, the EU seems to be following the kind of template approach, which I think would be consistent with the three-step test. It's interesting, by the way, if you haven't seen that document, in light of our discussions about fundamental rights in the EU Charter, the Commission and the Parliament, in drafting the directive and regulation, go through the proportionality analysis and go through the fundamental rights analysis, and they cite the obligations under the CRPD that attach to the EU and its member states. They cite the obligations under Article 17 of the Charter, and they say, well, this limited exception, which meets the three-step test, is consistent with the right of property recognized in Article 17.2. So they go through that balancing exercise both in the recitals and in the background to the legislation. So lastly, the last core point, and then I'll just say a few marks by way of conclusion about reflections back in the future, implementation. So the most basic commitment and implementation in the Marrakesh Treaty is to adopt an exception in national copyright law that permits the sharing, the creation and exchange of accessible format copies. That's not a hugely expensive proposition. Indeed, as I mentioned before, with regard to the example from Latin America, it may very well be that just adopting that exception really frees up national exchange or cross-national exchange of these sorts of works, and will lead to effective implementation of the treaty through a kind of private ordering. But I would argue that states can and should go further. The goal here is effective implementation. And to do that, the guide that I've co-published builds on the insight that all of the Marrakesh parties, or I believe all, if not almost all, and certainly the overwhelming majority, are already members of the CRPD. And in that capacity, they have already have obligations with respect to, as I mentioned earlier, the Article 30 with respect to not allowing IP to serve as a discriminatory barrier to access to cultural materials. They already have obligations to give effect to these rights for persons with disabilities in their national administrative state, whether that's through national human rights institutions, quasi-judicial commissions, or ombudsmen that have the goal of promoting and raising awareness, and in some cases enforcing human rights. Also, within government, there must be, according to the CRPD, a focal point for dealing with persons with disabilities. There must be consultations with disabled persons and their representative organizations. All that's already required. And so what we would urge is that governments do those same things with respect to the Marrakesh Treaty. That they don't, in other words, just hand over implementation and monitoring and enforcement to the Copyright Office or the IP Office, but rather that they engage with persons with disabilities who are very actively monitoring this treaty, that they create effective legal procedures to remedy violations, that they empower human rights actors like national human rights institutions at the local level to oversee implementation, and that, channeling what Surabi said this morning, that they report to human rights bodies on their implementation of the treaty, because they have to do that already under the CRPD. And I think by doing that, you will have a much greater chance that this new approach to using copyright tools to achieve human rights ends is likely to succeed. So in just a minute or two, I'd like to just reflect back on some of the other comments that we've heard, presentations that we've heard today, and think a bit about the future. And I want to really just make 3 points. The first is that in this area, because there is a multilateral instrument that is going to get replicated more or less in the same way around the world, there may be less need for judicial intervention. That is, maybe in this context, I can go back to something that Judge Arnold, you said earlier, when IP lawyers said, well, look, the balance is already struck in the legislation. We don't have to worry about it. We just have to apply it. Well, in this context, I might actually think that might be right. And to the extent we have, this multiple tests that are overlapping from different courts and different considerations, and whether we have them on a consistent basis or on an ad hoc basis, maybe we don't need all that if there has been a deliberative assessment that this is one of the ways that we should allow exceptions to copyright to flourish in order to benefit a specific community. So judges may not have as much of a role, and depending on what you've heard today, that you may think that's a good thing. In the end, of course, judges, I think, will inevitably be drawn in to some extent at the margins, but that may not make perhaps to the same degree as we've seen in some other areas. So that's the first point. The second point is I think this treaty provides for the real possibility for deep engagement between the human rights field and the IP field. That is to say, for the first time, I can imagine that at the administrative level, if judges are going to be somewhat out of the process, administrative agencies are going to be front and center. So whether it's human rights commissions within the government or alongside the government, as well as copyright offices and IP offices, there can be a shared mandate or shared competence over this treaty that would allow a kind of communication between different sets of stakeholders that I don't think we've seen at that level of granularity. And I think that's really quite promising or exciting. Although, the prior panel suggested there, always room to be less hopeful. And I take that point as a serious one. Finally, the last point I want to make is the idea of whether the VIP treaty, the Marrakesh Treaty, can be a model. I've already seen students and scholars begin to think about whether this is a new turn. WIPO is a new human rights organization. And now we will see treaties relating to libraries and archives. And in the WHO, there's a proposal for a medical research and development treaty that would work alongside with patents. And here, I guess I would sound a note of caution, at least in the short term and maybe in the longer term. And the note of caution is that this was a unique set of circumstances that brought this treaty into fruition. And my hat's off to the key negotiators. They really did something quite remarkable given the impediments that they faced. But there were certain political alignments as well as factual and legal alignments that made this multilateral instrument possible. I am not at all confident that those same alignments exist in other areas where users' rights, where the public interest is nevertheless, I think, our other speakers, and maybe some of you would agree, also quite strong. So how do we surmount that potential impediment? I'd like to see this treaty work on the ground. If it does work on the ground, if it can satisfy the concerns of the publishers and the copyright owners, as well as the needs and interests of users, it may serve as a template for the future going forward. Thank you very much.